We're fortunate to have with us today Roger Milgrim, who is the author of Milgrim's Guide to IP Licensing, published in 2012. Good morning, Roger. How are you?
Very well, PJ. Yourself?
Great. I'm fine. Thank you.
Good.
Licensing is huge right now. Licensing is where all the money is being made. So what would be the single best piece of advice you would give someone when drafting an effective licensing agreement?
I guess the single salient thing about licensing that makes it different from most other transactions is that it does not conclude when the parties sign the agreement the way an acquisition or merger or purchase of a building or purchase of equipment tends to end with the signing of the agreement. That's the beginning of the relationship between the parties. And that relationship will continue for the term, which can be very long. For a trademark, it could be indefinite, many decades. For a patent, 15 or 20 years, or not quite 20 years. For trade secrets, it can be very long. For copyright, very long. So to do effective IP licensing, you have to be a kind of playwright. You have to think about a scenario moving forward into the future. What things could happen that would affect your agreement with your licensor or licensee? And let me give you a couple of examples. One thing would be, supposing that a patent has been licensed and the patentee selected a licensee because, among other things, the patentee did not regard the licensee as a competitive menace or threat. Well, that's fine and well, but what happens if 3 years later that licensee is acquired, the company is acquired by a company to whom the patentee never would have licensed? And that brings into play such features as, do you need to have a change of control provision along with no assignment, etc.? That's one example of a future change. Another example of a future change is, suppose you have a process license. And the process license is for patents on the one hand and trade secrets on the other. And it calls for a royalty of a stated amount. What happens if during the term of the agreement the patent is invalidated? It becomes unenforceable. What happens to the royalty? Well, it's very clear that there are ways to protect against that problem, and that is to allocate the total royalty partially to patents in a reasonable way and partially to trade secrets in a reasonable way. But if you don't do that, and the patent fails in some way, then the licensor is going to see the royalty stream ended altogether. There are any other number of problems, and I won't dwell on all of them, but another one is, what happens if either of the parties enters bankruptcy? For example, in a typical high-tech license, there may be improvement provisions which call for both the licensor and the licensee to reveal improvements to one another. And that may be a major form of consideration. Well, that improvement phase is going to be affected by bankruptcy. And again, these are things that can be and should be taken into account contractually, but you have to think years into the future.
What do you see as being the most common mistake that people make when they're drafting these agreements?
Well, first of all, people are very imaginative in making mistakes, aren't we all? But I would say the common mistakes are a failure to adequately include the IP that's needed for the transaction. Let me give you an example. A typical process license for a high-tech process might include, or will include, patents perhaps, and trade secrets. And yet all of those process licensees are likely to have ancillary IP. For example, software that controls the process. For that, you really need a copyright license. Well, your first reaction is to say, why does that matter? After all, I'm doing business with this company, I'm paying royalty, they're not going to cut me off. Well, how do you know you're going to be doing business with the same licensor? What if they're acquired? What if they reorganized? What if they're acquired by your main competitor? You may find that a failure of having a critical IP component that was assumed but not expressly included is a serious mistake. Another major area of mistakes is the failure to really make crisp definitions. I would say a very large percentage of the litigation that comes up turns on the definition of key terms. For example, one party or perhaps both parties promises to the other improvements over time. What's an improvement? How do you measure an improvement? Well, there are lots of ways to do it. It could be based on the patent characteristics of a licensed patent, but there are better and more practical ways to do it, such as economic ones. If something improves the practice of the licensed IP by a stated percentage, then that's an improvement. That's another way to handle it. Let me give you some chapter references that could be helpful. Oh, by the way, one other important thing, and I've mentioned the need to make sure that you have the right IP components. That's what we call hybrid licensing. We cover that in Chapter 10 of the guide. Definitional considerations are addressed in many places, but they're collected at Chapter 5. The terms of the grant are reviewed primarily at Chapter 6. And things like change of control, assignment, etc., are covered in Chapters 21 and 22. The whole layout of the guide, the organization, more or less follows the pattern of typical IP transactions, so that even though the best way to use the guide is read it cover to cover once, after that you can use it as a desk reference for any given component, any given element of a license.
Great. Well, thanks very much, Roger. I appreciate your sharing your expertise with us. If you'd like to learn more about Roger's advice and how to draft these incredibly complex agreements, please visit us at wolterskluwerlb.com or contact your account sales representative.